Velkommen til dagens højt aktuelle webinar om de nye Economic Employer-regler over i Sverige. Mit navn er Mette Møller, og jeg har i en årrække sammen med min meget dygtige kollega Jenny Dahlin arbejdet med skatteforhold og social sikring i Øresund, eller rettere sagt mellem Danmark og Sverige. Vi har i dag allieret os med vores flotte svenske gentleman-kolleger, Örjan og Christian, som sidder i kontoret i Göteborg, og de vil sikkert og med rigtig god stil føre os igennem de længe ventede nye regler i Sverige om Economic Employer, og dermed udvidelsen af de svenske skattepligtsregler. En af de første ting, jeg kan huske i min karriere, der har strukket sig over et par 25 år, det var netop, at Sverige ikke havde den slags smålige regler om Economic Employer og arbejdsudleje. Det var kun os danskere. Men nu er det altså slut med at fjerne det rundt i Sverige og slippe for at betale skat af lønindkomst. Og det skal vi høre meget mere om i detaljer i dag. Og Jenny, vil du ikke give en kort introduktion til, hvad det er, vi ellers fokuserer på i Øresundsgruppen her i København?
Ja, og jeg har ligesom Mette også arbejdet med skatteforhold i Øresund i en årrække. Men til forskel fra Mette, så er jeg selv Øresundscommuter, da jeg bor i Sverige og arbejder i Danmark. Og i det her covid-19-år, så har vi meget fokus på det arbejdsmønster, som opstår, når medarbejdere i en høj grad arbejder hjemmefra, hvilket kan have betydning for beskatning i Sverige og Danmark. But now, over to Örjan and Christian.
Thank you, Jenny and Mette, and hello Denmark. Very nice to meet you like this in these very extraordinary times. So as Mette introduced here now, today we're going to talk about some new legislation here in Sweden, and that's the introduction of the economic employer concept. So we're going to guide you through these rules and what is applicable both for your employees and for you as employer. So the first part is kind of a little bit boring part, Christian, maybe. It's all about rules, but we will also describe these rules by showing a few examples and also present another set of rules which is also new, and it's not linked to the economic employer concept, but it's a withholding obligations for Swedish payers. And as a conclusion, we will summarize and give you some key takeaways, what to do, what are the next steps, and so on. So let's kickstart this now. So as a short background, and as Mette mentioned, you know, the economic employer concept has been applied in Denmark for many years, and also in Norway. So this is really nothing new. Many of our neighboring countries already has this concept and has applied those for like 20 years or so. So Sweden is one of the last countries implementing this set of rules. And it has been discussed quite, you know, for a long time here in Sweden, and before the summer, the Swedish government came with this proposal, and at the beginning of November, they made the law. The proposal was approved here in Sweden. So now we have that law. And generally speaking, and probably as you are aware of, the focus on business travelers is something that has increased over the last few years. Obviously, 2020 is a very strange year, but before that, before pre-COVID-19, it was quite big focus on business travelers, not only from a tax perspective, but also from immigration, social security, and permanent establishment issues, and also the Posted Workers Directive in the EU. So this is a really hot topic. So let's continue. What these new rules then, very briefly, Sweden will then start to apply the economic employer concept as from 1st of January 2021. And theoretically speaking, that means that we will no longer apply the 183-day rule of our tax treaty, and theoretically speaking, people that go to Sweden and perform work here and the benefit of that work is to a Swedish principle will be liable for taxes here. There are some exemptions and there are some assessments that needs to be done, and we'll guide you through those later on. But these changes means then taxability for the employee and a reporting obligation for foreign employers. And as I mentioned, these will be in effect rather soon than from 1st of January 2021. So what does this rule means then?
Okay, so heading into the rules then, and we clearly state, as mentioned by Göran earlier here, that this new rules would have implications for both the employees and the employers and foreign employers, but also some implications for Swedish companies hiring people from abroad. But just to start to set of new rules in a context to what has been applying in Sweden previously and are being applied today. So currently Sweden applies a formal approach to employer concepts, where we merely looks at who is the employer, who has the employee have an employment contract with, which company pays the salary. And this has led to that people going into Sweden or working in Sweden from abroad has been able to be here in Sweden and perform work for quite some time without being taxable in Sweden. So an example of that is if you're looking at the Swedish tax treaty with Germany, a company from Germany sending employees to Sweden for work has been able to perform, or the employees has been able to perform work here for 182 days on a calendar year without being taxable in Sweden at all. So this is what the government of Sweden would like to change, and they would like to have the employees being tax liable at an earlier stage. So how will then this approach change, and what would be the consequences? So as earlier mentioned, Sweden will introduce an economic employer concept, and this will be relevant when looking into the 183 days rule in the tax treaties, but also Swedish internal law. So for foreign companies sending in people to Sweden or making staff available for work in Sweden, and the benefit of this work could be lying on the Swedish company, then the 183-day rule will not longer be applicable, and it will be theoretically taxed from day one. So you need to have, according to the Swedish rule, then 3 parties involved in this setup. So a foreign company hiring out people to a Swedish company or a company performing services in Sweden, and employees physically working in Sweden. And if you have these 3 parties, and you also could, based on some factors we show you later on, say that the benefit of this work, what the employees are performing in Sweden, could be beneficial for the Swedish company, then you have an economic employer situation. But there is an exemption from this, so you could still have the setup. There is an exemption, which we will talk about more later. But just to be perfectly clear here, according to the Swedish rules, you need to have these 3 parties to be able to create an economic employer situation. So you need to have a former employer, a company abroad where the employees are being employed by and receive the salary from. You have to have employees traveling into Sweden, physically perform work in Sweden, and you have to have a company, Swedish company or a foreign company with an establishment in Sweden conducting business in Sweden, will have the situation that the new rules talks about. So if you have all these parties involved in the setup and you have a sense of the benefit lying on the Swedish company, you may have an economic employer situation. But as I mentioned earlier, there is an exemption from the rules, even though you have all this, everything here has been fulfilled.
Yeah. May I add one thing to this picture, and it's based on experience. And we have a tricky situation when we deal with, let's say, subcontractors and self-employed foreign individuals, and that is a discussion that has been ongoing here since the law came into force. So that is a tricky situation, and that situation is nothing that we're going to cover today. But we know that is very common. So now we're more or less talking about regular employees employed by a foreign entity coming to Sweden, serving a client or a customer or doing some work here. So we're not talking about subcontractor situation.
Yeah. Okay, so heading into the exemption then. So the proposal in the new rules, or the government's proposal to attack these new regulations, is to see, okay, the first step, will the general exemption apply? And the exemption here is connected to work days in Sweden. So the first thing that the foreign company needs to review is whether their employees has been in Sweden for 15 consecutive work days. And if they have exceeded, the work days in Sweden have exceeded 15 consecutive work days, then the employees, assuming there is an economic employer situation, will be taxable from day one. But if the trip to Sweden is less than 16 consecutive work days, then we won't have any tax liability in Sweden at all, even though that we could say there might be an economic employer situation here, or economic employer setup. And the second one to look into is the threshold of 45 work days in a calendar year. We will have an example later on just talking about this exemption, but theoretically an employee could be traveling to Sweden for, let's say, 3 trips, and each trip is just 15 consecutive work days, and still be exempted from taxation in Sweden. And there also have been some clarifications from the governments regarding this exemption, because if an employee exceeds the first 15 consecutive days, as I mentioned, will be taxed from day one. But having an employee going to Sweden for, let's say, 3 trips, so 15 days each, and then heading back for a 4th trip and exceeding 45, then it will be taxed from day 46. So that's an important thing to remember here. So exceeding 15 days, tax from day one, but exceeding 45 days, tax from day 46.
Yeah.
And you something you'd like to add?
Yeah, sure. And as you can see, first of all, it's a big difference than when we look up on the number of days that you actually can spend here in Sweden. It's 183 compared to 15 or 45, so it's a big difference. And when you look up on the calculation of 15 and 45, there could be some challenges around this, and we will show that with an example later on, as Christian mentioned. So this is maybe, apart from the assessment whether it's an economic employer or not, this is a challenge to keep track of your employees being in Sweden.
Yeah. We're talking here about 15 consecutive work days or 45 work days in a calendar year, and it also have been clarified in the proposal or in the new rules how you break these or stop these consecutive work days in Sweden. So what's mentioned in the new rules is that you have to, or the employee has to perform some kind of work activity in their home country or another country, but abroad from Sweden. So it's not good enough for the employees to be heading back home to their home country on a leave, let's say. So working in Sweden Monday to Friday, so that will be 5 consecutive days, then heading back over the weekend. This will not stop the consecutive days. If the employee is going back to Sweden on the following Monday, will be regarded as the sixth consecutive day. So some kind of work activity has to be performed back home or in another country outside of Sweden. You can see the last bullet point there, that this exemption is not limited to intra-group travels, because in the earlier proposal for the new legislations, the government proposed that this exemption will only apply for intra-group travels. But it has now been clarified, and this is the new rules, that the exemption applies for all travels to Sweden. So, okay, if we have a foreign company making staff available in Sweden, employees traveling and performing work in Sweden physically, and a Swedish company has these employees at their office or at their building site or anything, and we could clearly say that the employees have been performing work in Sweden exceeding these thresholds, then we need to assess whether we have an economic employer situation or not. And this slide here shows the guidance which the government has provided us with. So they say that it is taken from the OECD's model agreement. It also applied in the tax treaty between the Nordic countries. And what the government's saying is that you have to do a joint assessment of these factors here. They're not saying that each or any one of those are more stronger than the other one. They're just saying that it's a joint assessment. So when the employees performs works in Sweden, you need to review whether it would be under the control of the Swedish company, and is it directly charged to the Swedish company, or the Swedish company provides materials or tools or anything. So these kinds of questions is what you have to ask yourself when sending out employees to Sweden. And also, we will say an important factor here is who bears the economic risk for the contract.
Right.
So is the Swedish company having a contract towards a customer, and they use your employees to perform the service to their customer? That's another indication for one might have an economic employer situation here.
Right. So yeah, just to add some thoughts about these bullets, and as Christian mentioned, these are taken directly from the OECD model treaty, and in some sense they are very formal and maybe a little bit outdated. You know, if we look upon how we work today, and we expect that we will get more guidance from the Swedish tax office about how to interpret these bullets, and also I'm quite sure there will be court cases where the economic employer concept is assessed. You know, how we work, where I can actually take my laptop and sit wherever I want, could be a challenge here. I know that you're not prepared for this now, Jenny and Mette, but you have had the economic employer concept for some time in Denmark, and are you able to tell us about if the Danish authorities has given some guidance around these bullets, and because what I think is actually that the Swedish tax office will do is actually look upon Denmark, Norway when they interpret these rules. So you say something briefly when it comes to Denmark, how you apply these.
I would be happy to share a little experience or what we've learned in Denmark. And what we can say, I think, is that we have people that could sit everywhere and when they work from their home, for example, sometimes we have the question, will that trigger a tax liability for a foreign employer? And in that respect, we have a clear understanding, or at least we're working towards that shouldn't have any impact on what is going on, because it's not because of the employer that the employee is working there. It's a private decision. So in that respect, we do look at that, not directly together with the economic employer concept, but at least a little bit.
Right.
Yeah. So a joint assessment then of these bullet points, and as Arja mentioned, we expect this to be a hot topic in Sweden for the coming years, and hoping for some guidance on thoughts from the Swedish tax agency, but also looking to court cases and see how to apply these rules. But also, I think and we think that the Swedish tax agency will look on how the different Nordic countries applies these rules.
Yeah. For sure.
Okay, so if we have then looking into all the factors and exemption and everything, and making the assessment that we have an economic employer situation, what will be the potential liabilities for the employees? So we will say for most of them, they will not have that many trips to Sweden, and they will have a limited stay in Sweden, and most likely then be regarded as non-tax residents in Sweden. And non-tax residents in Sweden will be taxed in accordance with the non-residents, especially income tax for non-residents, or SINK short, which is a fixed tax rate of 25% on employment income. But they will also have to apply for a special tax number in order to report the SINK. And that could be handled by the employer, or could also be handled by the employee. But yeah, the potential liability and the most common situation here is likely that the employee will be taxed on their work days performed in Sweden in accordance with the SINK legislation and a 25 tax rate on employment income. But another important thing to remember here is I would say likely or in all scenarios, the employee traveling into Sweden will have their salary paid out from their home country, and there will be preliminary tax withholding in their home country. So the Swedish taxes will be an additional tax for the employees. So it's a question how to handle this additional tax for the employer to not have any impact on the employee's net salary. And this will be, in the end, solved by applying the tax treaty. And a common scenario is that you claim for a tax credit in your home country's tax return. But it could be a potential cash flow problem throughout the year until everything has been handled within the income tax return for the employee. So that's another thing to remember. An important thing here is that we will have an additional tax burden throughout the year.
Yeah, and another take on that is also that this is actually kind of a employer responsibility, taking care of your employees and making sure they are not double taxed, and at least if they will end up in an economic employer situation in Sweden, they get the information, they know what to do, and they are prepared for this potential cash flow issue that can occur. Because this, depending on what country we're talking about, this can take some time to claim these money back in your home country.
So now we have covered the new impact for the employees with the new rules and some of the obligations which might be applicable if all the if all the criteria has been met for creating an economic employer situation. Now we're going to head into the new obligations for a foreign employer. And using the same approach as for the employees, just you wanted to set a context, what is applying for foreign companies having employees in Sweden right now. So currently, foreign companies with no permanent establishment or tax establishment in Sweden are not obligated to register themselves as an employer or to withhold taxes in Sweden. So even though you having employees working in Sweden exceeding the 183 days rule, being tax liable in Sweden, there are no obligations at all for foreign company if you don't have a so-called permanent establishment. That the liability instead lies with the employees who should handle their tax withholding themselves. So this will also change when the new rules implements in Sweden. So the new rule says that foreign company with no permanent establishment having employees tax liable in Sweden should register themselves as employer in Sweden and should handle withholding tax in Sweden. So if we take the example we talked about earlier, sink tax for employees. So the foreign company should then register themselves as employer and withhold and pay sink tax on the behalf of the employees. So that's a big change from the current situation we have right now in Sweden. There also has been a discussion when these rules presented by the government whether Sweden should allow something we call shadow payroll here. So should the Swedish company, let's say in a situation, intra-group situation, should a Swedish company in the group be able to handle the reporting and the payroll reporting for the foreign company? And this has also been cleared out by the government now that we are not allowing any shadow payroll in Sweden. So in this case, it is the foreign company who should register themselves as employer and should handle the reporting in Sweden. So you could not transfer this obligation to the Swedish company within the group. And there has been some proposals from the government on to handle this. I would say that a common solution, or the proposed solution, I would say, is that the Swedish company within the group could apply for power of attorney and handle the reporting from practical perspective, but formally it is still the foreign company who should be reporting in their name. Yeah. So also an important change here when heading into the new rules, the 1st of January. Okay, so now we have been through the rules, we have been through the implications for the employee and the employer. Just taking some examples now to see, okay, what guidance have we received from the governments in these cases.
So these are actually taken from the original proposal then written by the government. So the first example here is a quite clear case of a non-economic employer situation where the 183-day rule is applicable, and we do then have the foreign company sending an employee to Sweden for another group company, and this employee is going to do some work around the group's marketing strategies on behalf of the parent company. So it's no real benefit to the Swedish entity. It's more a strategic role that comes into Sweden. And in this example, the parent company obviously not has a permanent establishment here in Sweden. And this stay will then last for 5 months. So that is less than 103 days. So, and as I mentioned initially here in this case, this is a quite clear case of non-economic employer situation, as this individual is performing the work on behalf of the foreign entity X Limited in this example. I think that's quite straightforward.
Yeah.
And the second one, Christian.
The second example then, this is what the government considers a clear case of an economic employer situation. So here we have the same assumption as earlier. So a foreign company with no permanent establishment in Sweden, the stay of the employee will last for 5 months, and the employee will not return to Sweden after that during the same calendar year. But in this case, the employee will travel to Sweden to act as a CFO in Sweden for 5 months. And the work is conducted as part of the Swedish subsidiary's business, and the Swedish company will provide tools and materials and instructions to the employee. So here the government says, as I mentioned earlier, this is a clear case of economic employer situation. The Swedish company will be regarded as an economic employer, as the work the employer performs is for the benefit of the Swedish company. It is the Swedish company who provides the workplace, provides tools and materials. And it also has been mentioned by the government here that even though it could be a case of receiving instructions from the company X Limited here, or they provide instructions and so on, they will still have no change to the conclusion here. So even though you could have a scenario, let's say that the strategic decisions and instructions comes from X Limited, but will still be regarded as an economic employer situation here.
Right. So the third example is we have now we have two Swedish entities really in this case. It's XAB that has engaged Builders AB to do some repairs on their facilities. So the repairing work is not really the core business of XAB, but it is the core business of Builders AB. And Builders AB, they need some staff to do this work, so they have engaged a foreign staffing company, Staff Limited, to man this project and do the work here in Sweden. And it is Builders AB that controls this staff, and they will also provide tools and material and do the supervising of this staff. So then in this situation, Builders AB will be the economic employer in relation to this hired labor, because this is the core business of Builders AB doing the repair work factory of XAB. So I think this situation is, I would say, at least in the construction industry in Sweden, this is quite common. But as I mentioned initially, we do not cover, the situation where we have self-employed people in this situation. So that is a separate issue, and that needs to be analyzed separately.
Yeah. Okay, the last example then, that's the example with exception and trips to Sweden. And the general assumption are the same. Foreign companies sending people to Sweden, no permanent establishment. But in this case, we have an employee who will be traveling to Sweden, performing work under supervision and receiving instruction from a Swedish company. So an indication that we have an economic employer situation. But the stay in Sweden will only last for 15 consecutive days. And the employee will then return after the first trip for another trips, 3 another trips to Sweden. And the stay in Sweden will last for 15 days in these trips as well. So in total, 4 trips in Sweden, then 15 each. And this is just to as we discussed earlier, to make a clear case of, okay, when will the exemption apply and when will the exemption no longer be applicable? And in this case, then, the first 3 trips will be the first trip or the income from the first 3 trips will be exempted from taxation in Sweden. So the exemption will apply for the first 3 trips, easily saying. But when exceeding the 45 work days threshold in the 4th trip, then it will be taxable on day 46 from the employee, and the foreign company will be obligated to register themselves as an employer and to report and pay tax in Sweden from day 46. Yeah.
Right.
I don't know. I think I'm doing this again, Mette and Jenny, even though you're not not being prepared with it. But do you recognize these examples? Is it something that is near the Danish approach as well for economic employer? If not looking at the exemption, but just talking about in the first example a strategic position, and then example 2 more acting on behalf and so on. Is this something also you're looking at from the Danish perspective?
Yeah, actually, in Denmark, it's very much alike. What we don't have is those thresholds of 15 and 45 days, unfortunately. That would be good. I think the shadow payroll is actually something we can work with. So that sounds a little harsh, seen from a Danish perspective. But actually, I also think I would like to ask you a question, because I think as a Danish employer that sends people to Sweden, how would you suggest that you monitor people coming in and out?
We will say that for most of the employers, the Danish employers, of course, you have to consider the amount of people traveling to Sweden, but some kind of technology solution will be necessary to monitoring this.
Yeah, and what other companies do, like the tracking days, and they're, as Christian mentioned, it obviously the volumes of travelers. We can do it manually if it's a very low volume. There are also technology solutions available on the market, and you can use travel data maybe from the travel provider if the travelers are booked via a travel agency. Obviously, in the relation between Sweden and Denmark, people might go by car using the bridge, coming over with the ferries. So then it's really, as an employer, you need to talk to your employees about this and make sure that they are reporting the work days here in Sweden back to the employer. Otherwise, it's almost impossible to know and keep track. There are some calendar app solutions where you can, automatically track people, but that could also be a sensitive situation and a discussion to have. So, could you hear that one? Okay.
Good. Okay, heading back to the presentation then. So these were the examples we want to raise during this presentation. Another thing we like to raise is, and as Erland mentioned earlier, it is not connected to the economic employer implementation in Sweden, but it's included in the same legislation package provided from the government. So there's a new obligation for Swedish payers to withhold tax. So if you have a Swedish company or a company performing or conducting business in Sweden who pays or hire in personnel for perform work in Sweden and pays these invoices for this work, they will be obligated to withhold 30% in a preliminary tax if not the foreign company had something called a Swedish F-tax certificate. So it used to be connected in the early rules, it used to be connected whether the foreign company had a permanent establishment or not. So if the foreign company had a permanent establishment, the same obligation were for the Swedish payers to withhold. But now this will be changed and instead be connected to the Swedish F-tax registration. So there's another registration for a company. So you still have the registration as an employer, you have the reporting in payroll if the employees will be taxable. But even though if the exemption is applicable or you don't have an economic employer situation at all, you still have this lying within the new rules that the Swedish company then will have to withhold 30%. So we were talking about a cash flow problem here for foreign companies having employees performing work in Sweden. And it is also important to say that it doesn't mean that the foreign company has to pay tax in Sweden or has a tax establishment or permanent establishment in Sweden. But it's a way for the Swedish government to be able to gather more information from foreign companies performing activities in Sweden. So the application as such for a Swedish F-tax does not include an assessment of permanent establishment. But we will say that it will be a high risk or a risk, let's say, for the Swedish tax agency heading back to the foreign companies applying for F-tax and asking them about the activities in Sweden and how many people and for how long and so on. But from a theoretical perspective, it's still possible to having these 30% being paid by the Swedish company or being withheld by the Swedish company and then being able to claim it back. But as in the same way as for the employees claiming the Swedish SINK tax back, it will take some time. So we will have another cash flow. And from Swedish companies or companies performing activities in Sweden, we will have an additional administration here.
Right. So just a few words about some other considerations from a compliance perspective, because now we have, talking about tax issues for the individuals and for the employers. So there are some other considerations to make as a foreign company or a foreign individual coming into Sweden. First of all, it's the permanent establishment issues, which is a corporate tax thing. That is if you're doing business in Sweden and you have profits and potentially they might be then taxable in Sweden. So that is something that you need to look upon. And connected to this new legislation now in Sweden, we anticipate that the Swedish tax office will take a closer look at companies that as a consequence of the economic employer rules, register in Sweden, having personnel here, the tax office will get much more information about foreign entities conducting business here in Sweden. So we anticipate that Swedish taxes will come back with more questions than before regarding permanent establishment. So that is something we anticipate going forward. Social security is a big cost here in Sweden. So it's very, very important to make sure that all foreign employees that are coming here to work have the certificate of coverage, the A1 forms, if possible, and then you can avoid Swedish social security. Also, from an immigration perspective, that is also a hot topic here in Sweden. You need to make sure that you have the right work and residence permit to be able to stay and work here. So that is important. And also a very, very hot topic with the entire European Union is the Posted Workers Directive, which in Sweden you need to register online at the work environmental authorities. And we did have a new set of rules this summer about this, and you need now to register from day one. But if you're working, with the cross-border issues within the European Union, this is something that you are aware of.
A big conclusion we could say is that the Swedish government is trying to gather more information on like activities performed in Sweden to clearly try to get more taxes as well.
Yeah.
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 So
yeah, and you know, as you all have seen all over the world, actually, it's a global issue that many states trying to collect more money from both people and companies that are conducting business in their countries. So this is a let's say kind of international trend, I would say. So just a few takeaways regarding the economic employer concept in Sweden. As I mentioned, the rules will be coming into force 1st of January 2021. So it's really now time to prepare. Need to keep track of the people that are coming to Sweden. I need to then assess what kind of obligations that you have from a compliance perspective, and maybe set up internal rules, internal communication plan, internal information packages on how to handle the travelers to Sweden, and also maybe taking a more broader look on a higher level regarding the entire business traveler population, because this is a hot topic in many regions, many states. So this is a growing issue, I would say.
that was the presentation. So questions.
Yeah, we have some written questions here. I don't know how you want to deal with those. Should we take them in you close that one?
Skal jeg sige det med? Yeah, okay. I think we will take just some of the questions as we just have limited time. But one of the very good questions, I think, is how is it that you actually register in Sweden? Do you do it on the internet or as a web thing, or do you need to send in papers, or how do you actually, as a Danish company with Swedish people being sent to Sweden, how do you register?
Oh, it's my question.
Yeah, it's your question. We discussed this actually before the webinar, but I think Christian is the right person to respond to this.
The registration employer by paper and sending in via post.
Yeah.
There have been discussions to open an online filing as well for this one, but it hasn't happened yet. But the Swedish Tax Agency have been able to launch online registration for SINK, or the special income tax for non-tax residents. So that could be handled by online. And they also clearly stated that they will have two lines for the application. So all the ones who has been filed online will have a priority before the one on paper.
Yeah.
But another question we have been discussing internally, and we haven't seen any published guidance from the tax agencies yet, is to how to handle the reporting we talked about connected to Swedish F-tax and the withholding requirement. So we have the same situation today. If a Swedish company hires a Swedish company with no F-tax certificate, so there is a solution for that, but it hasn't been provided any guidance on how to report and withhold tax, or to especially claim back the taxes for a foreign company.
Yeah. So
that's just something we're waiting on.
Yeah. And then another question that we have received from many of our clients, it's a more practical question because quite many foreign businesses that actually conducts business here in Sweden. It's in many companies that's sending people here on a business trip, and if all of these would register in Sweden as from 1st of January 2021, the Swedish tax office would have quite big work task ahead of them. So what we hear regarding that point is all of them they will be registered, but it's nothing. But they might not be reviewed. So the Swedish tax office has kind of, and it's also a part of the proposal, saying, okay, we might come back to you at the later stage reviewing your application and potentially then make a permanent establishment review as well. So they have set out some possibilities to reach out at a later stage, because the registration will be a massive work task for them.
Yeah, and just in terms of the F-tax registration, as earlier mentioned, it's specifically mentioned in the proposal or the new rules that foreign companies will be obligated to send in information to the Swedish tax agency about their activities and so on. But there could be some additional information they need to share, but also something we're waiting on guidance from.
Yeah.
I think there's also another thing that would be nice if you just make very clear that if I'm starting to be there on the 16th day or the 56th day, will I then be taxed backwards or forwards? I think you have already answered it, but I think we need to do it very clear that it is something going forward. So please elaborate a little bit about that.
Yeah, of course, and that was a hot topic in Sweden also regarding the proposal. Okay, let's say if we have an employee traveling to Sweden and we make the assessment in December that the person has exceeded the threshold, should we go back then and handle all the payroll? And this is specifically why they have made that difference between 15 and 45. So if you have an employee who exceeds the threshold of 15 consecutive days, then you have to go back to day one. So you have to amend the payroll or establish the payroll from day one. But if you have an employee in the example that we mentioned, example 4 here, going back and forth, but then on the 4th trip or the 5th trip exceeds the 45 threshold, then you will have to register yourself and handle payroll on day 46. So you don't have to go back to the first day when the employee entered into Sweden or started to perform work in Sweden.
This is, the conclusion from this is, this makes the calculation and the tracking of days very complicated. You need to be kind of very, very on top of things and be aware of where are your employees and what are they doing.
Yeah.
I was also wondering if do you expect that we are going to have some fights where you claim that you were actually not working, you were just staying, but then, for example, you had to take an urgent call, and did that trigger a work day then? Do you expect that we have to be sort of fighting with the Swedish authorities about, is it a day of a stay or is it a work day?
I think that's kind of $1 million question because it's impossible to know what you do during days, and that's when we discussed the bullets from OECD, and this is one of the critical questions that we could encounter because it's the way we work today, where our free time and our work time is actually linked together, especially when we now, during the COVID-19 period, we have all learned on how to work from home. So I can, work whenever I want. So this is a very, very tricky situation. But formally, if I would say if the tax agency says that I have been working, they have to prove it. Yeah, they have to prove it that I have conducted the work. So, and that would be a difficult task for them to prove, actually. The only way of doing that is if they, see if there's time sheets and that kind of stuff. I would say, or invoices maybe. I don't know, but that is a $1 million question. I would say it's a good question. It's a very good question.
For us working with these questions on a regular basis, it will be interesting to how the Swedish tax agency will apply the new rules, and how their activity will be towards foreign companies, Swedish companies, and so on.
So maybe also a little negative question. What do you expect will happen if then some foreign employers actually miss that they should obey these rules or respect these rules? What sort of consequences will they have to face?
Well, let us take a few steps back and look upon the purpose of these rules. And the purpose of the rules is to catch employer and employees that, let's put it like, made an overuse of this, the 183-day rule of the treaty. That's the purpose of the rules. And then they have mentioned, special, some certain businesses, such as construction, transportation, restaurants maybe, some IT consultants, maybe a few more, but where you systematically go under the 183-day rules.
And having employees going on a rotation scheme.
Employees going on a rotation. So that is the kind of the purpose of the rules. And obviously there is a battery in Sweden with penalty fees and also criminal charges if you clearly violate the rules. So they have tools to hit this kind of systematically tax avoidance scheme, so to speak.
So goodbye. Okay. Yes, and to wrap it all up, we'd like to say a big thank you to Örjan and Christian in Göteborg, and also a big thank you to our IT technicians behind the camera, Nicoline and Simone. And if you have any at all more questions, you're most welcome to reach out to the four of us. Thank you, everyone.
Thank you.